Welcome to this class of the State Library of Iowa's Director Endorsement course about HR and volunteer management. This class is about disciplining and firing. This class contains legal information regarding recommended best practices from legal experts, including an attorney at Brick Gentry Law Firm. However, it is not legal advice. You should consult with your city's Human Resources Department or your city attorney for legal advice concerning matters of employee discipline and termination. My name is Mary Ann Morey. I'm the consultant for Central District at the State Library of Iowa. In this session, you will learn about these employee situations that we all hope will never happen, but if they do, you'll know more about how to deal with them. Here's what we anticipate you'll acquire from this class: the ability to define reasons when employee discipline may need to occur, understand what employee discipline is and why it's necessary, develop best practices for dealing with employee performance issues, and apply recommended procedures when necessary to dismiss an employee legally after consulting with your local attorney. Employee discipline should occur when an employee does something that is against the rules of the library's expectations or the city's personnel policy or any local, state, or federal laws. Even employees who have always been great can have moments when discipline or coaching might be necessary. Listed here are some common reasons when you might need to discipline an employee. Poor attendance. This can include chronic tardiness, misuse of leave time, or unauthorized absences. General misconduct, such as insubordination, rudeness either to library staff or patrons, or a volatile personality that causes issues. Poor performance, not getting tasks done, constantly sloppy work, misuse of staff time, inability to perform the job description's expectations. Misuse of resources. This includes using staff email or the internet on a work computer for a personal use, misusing the library's social media, making personal photocopies without paying for them, etc. Theft of library or city materials, property, or money, and harassment or discrimination of staff or patrons. If you will recall from our class about performance evaluations, the Library Board of Trustees oversees the director and only the director. Our state law library says this: remember that managing library staff is the director's responsibility, not the board's responsibility, and therefore it is rarely, if ever, necessary for the director to discuss specific personnel actions with the board. Trustees should not sit in on hiring interviews, staff evaluations, disciplinary meetings, or terminations. Directors do not need the board's permission or consensus to hire, discipline, or fire a library employee. The director must only follow any procedural rules adopted by the library board and the city to ensure that the hire, disciplinary action, or termination is well documented and legal. We all hope we never have to discipline our employees, but reality is that it can and likely will happen at some point during your management career. Having a good process set up in advance and being consistent are the main keys to this process being less stressful and successful. The goal isn't to fire someone, rather it's to change whatever behavior occurred for the better. Don't ever try to discipline someone in the heat of the moment because that won't end well for anyone. Having a well thought out procedure and process will help you, the manager, be fair and consistent when dealing with employee disciplinary measures. If you are a solo librarian, realize that many of these steps can apply to overseeing library volunteers. You should also be aware of the necessary steps involved in discipline, so you will understand if your board is following best practices for any disciplinary actions they might take with you. Here are just a couple of definitions of employee discipline. They differ a bit, but mostly indicate that rules or regulations are necessary to ensure a safe and orderly organization, or library in our case, and failure to follow those rules results in discipline. Many times that discipline will deter an employee from continuing the unacceptable behavior. Encyclopedia.com defines employee discipline as actions imposed by an organization on its employees for failure to follow the organization's rules, standards, or policies. Study.com defines employee discipline as the regulations or conditions that are imposed on employees by management in order to either correct or prevent behaviors that are detrimental to an organization. While delivering discipline is difficult for any director or supervisor, having an effective procedure is necessary. We mentioned in the successful hiring class, part of this HR and volunteer management course, that it is advised to have expectations of the job clearly spelled out by having an updated job description. Having a personnel policy and similar employee expectations, such as procedures for requesting time off or for taking breaks, are also vital to establishing the expected guidelines of employee behavior. While the steps on this slide won't always keep disciplinary issues from occurring, they will make them fewer and easier to address. Any workplace code of conduct and expectations need to be clearly communicated to each and every employee and volunteer from the beginning of their arrival at the library. If you're a solo librarian in a small library, don't think this doesn't apply to you. Your library's policies and procedures and employee expectations need to be compliant with state and federal laws, and they need to be consistently enforced. When they aren't, you will definitely have discipline problems. Put your personnel policy and any personnel procedures in an employee handbook or a volunteer handbook, as the case may be, and give a copy to every new employee or volunteer. The handbook may include guidelines for requesting leaves of absence, personal time, vacation, sick leave, and such, dress codes, continuing education expectations, and procedures, and grievance procedures. Ensure that you take the time to adequately train every new employee or volunteer. This can help ensure that workers know and understand the rules and expectations and can prevent employees from later saying, "But I didn't know that was an expectation or rule." Having employees sign off on receipt of such information is advisable. If employees believe they are being treated fairly, they are much more likely to accept the consequences of their actions. Consistent and fair discipline will also help to prevent successful claims of discrimination or other unlawful conduct. As noted in our class about performance evaluations, part of this HR and volunteer management course, you should be conducting regular, at least annually, performance evaluations of every employee. Be sure to refer to that class to understand the importance of having properly prepared employee evaluations. Having a similar kind of volunteer review can also be a good way to ensure continued good performance and/or address corrections that need to be made in any volunteer behaviors. Once employees see the discrepancy between actual and expected performance, the burden is on the employee to change. Even with more positive approaches to discipline, organizations still need to have some form of disciplinary procedure that carries successively stiffer penalties for repeated or more serious offenses. These are some common rules or expectations by both the library and the city as to behavior in the workplace from the Society for Human Resource Management. These could be additional elements of an employee handbook. Included are rules governing day-to-day situations such as attendance, tardiness, and dress. It is also advisable to include a definition of tardiness. Rules defining what is permissible regarding use of library phones, computers, and other equipment for personal use. You should also include rules regarding the use of personal phones on staff time. Rules governing more serious conduct, such as substance abuse, workplace safety, or sleeping on the job, and situations or conduct that may lead to immediate suspension or termination, for example, violence in the workplace or embezzlement. Here's a recommended general discipline process. Progressive discipline provides opportunities to inform the employee and give them time and support to make positive changes and improve performance. You don't want the first time the employee hears of a problem to be in their annual review. You might want to adopt a similar process if you don't have one, or include some of these actions into what you currently have in place. Before you start any discipline, make sure you have a full understanding of the problem and that you are being accurate and have an impartial assessment of the employee's conduct. Let the employee know they've done something wrong or that there's a problem. You don't want to write them up without their knowledge of a problem. This step can be a conversation with the employee, but make sure to follow it up with an email so it's documented. More on that later. Coach the employee on the correct method or response or process, etc. This can be as simple as discussing what should occur and giving them some simple steps to move them toward improvement. Sometimes coaching is really more like training on a process or expectation. A verbal warning should be given when the employee does something that goes against work rules or policies. Again, it is imperative that you follow up with email. If the employee has historically been a good employee and suddenly you're noticing some concerns, then you can certainly say something such as, "You've been a stellar employee, but I'm noticing a change in your behavior. Lately you've been," and state the cause or the concern. Then ask, "Is there a reason for this change?" This is the kind of discussion you might have with the first verbal warning. At any verbal warning, be sure to let the employee know that the situation will be monitored. If you, the supervisor, see no improvements, you will advance in the disciplinary process. A written warning documents in detail the seriousness of the offense, future expectations, that is, what the correct course of action should be, and future consequences, or what will happen if the change doesn't occur or if the employee repeats the problem. The written warning should be signed by the director or supervisor and the employee. Give a copy to the employee and put a copy in the employee's personnel file. You can issue more than one written warning before moving to the next step. Having the employee sign the written warning does not mean the employee agrees with the details. It simply gives verification that the employee has seen the written warning. Final warning. Before issuing a final warning, you will want to consult with your HR facilitator or local attorney. The final warning should be in writing, and it should include previous warnings and how the employee failed to improve. This final warning will indicate that termination will be the next step of action. Probation might be considered as another step. During a probation, you might require retraining or close supervision of the employee. Sometimes an organization will allow an employee to resign in lieu of termination. Again, you need to talk with your HR department if you have one, or with your city attorney. The final step is termination. One important thought on discipline is that you want to make the punishment fit the offense. You certainly don't want to fire someone for dressing inappropriately one time. That would be way too harsh. Coaching the employee on why their choice wasn't the best would certainly be more appropriate for the situation and would not end up with the employee ready to file a lawsuit. Using mediation and arbitration can also work well if you have two or more employees who are having an issue with each other, not necessarily a problem between an employee and management. These steps are usually required in any union environment, but are usually faster, less expensive, and less formal than a potential lawsuit. Mediation is a voluntary process in which a trained, neutral person works with both parties to facilitate an agreement to resolve their dispute. If the problem is between two employees, a manager or director can act as the mediator, but it is advisable to bring in someone from outside the library for neutrality's sake. You don't want the impression of favoritism. A good mediator will help the parties see the bigger picture and come to a compromise or come to an agreeable solution that allows ownership of both parties. In many cases, this step will solve the problem. If not, then you can go to the arbitration step. Arbitration is a process where both parties agree to have a third party review and make a decision on the course of action to be followed. North Central College defines arbitration like this. Arbitration is a way of handling a conflict without going to judiciary court proceedings. In an arbitration hearing, an arbitrator oversees a legal dispute between two parties, whether they're companies or individuals, and listens to both sides of the story before coming to a conclusion. In short, arbitrators offer a practical alternative to legal arguments. Because lawsuits are often costly and time-consuming, arbitration can be an attractive alternative to a drawn-out public trial. Consult with your city and city attorney before pursuing either of these steps. A key part of employee discipline is to document everything. Document, document, document. The recommendations on this slide are from an Iowa attorney from Brick Gentry Law Firm who presented a webinar on legal aspects of management for the state library a few years ago. Recommendations for documentation include the who, what, where, when, and why of the incident or offense. You will want to document every time an incident or offense occurs, as well as every time you address the situation with the employee. Document the impact the employee's behavior had on the library or other employees or patrons. Document what should have happened, how the employee should have behaved, and reference any established personnel policies or procedures the library already has in place. Note the consequences of future occurrences on any written warnings issued to an employee. Document the employee's response to the situation. For instance, how they reacted to your verbal or written warning, whether or not they completed any required training as a result of previous discipline, etc. Realize that email and voicemail can be acceptable and effective forms of documentation. You may, however, want to start a journal or spreadsheet log of entries and dates of occurrences or emails or voice messages if this is an ongoing problem. Failure to adequately document situations and failure to use email or voicemail can definitely work against you and your library or city should litigation occur. We cannot stress the importance of documentation enough. In all cases of discipline, as well as any coaching, you want to make sure you document everything. Documentation starts out as notes for the employee's file that you make during their evaluation or when you've commented to the employee about something you want changed. This can be as simple as noting when the person is late or not prepared for doing part of their job. These don't count as part of the process of discipline, such as a written warning, but definitely they establish a pattern of behavior. If you have a conversation about a problem, then it's advised to make sure you follow up with an email to the employee reviewing what you talked about in case a disgruntled employee later files a suit against discipline or termination. If you've taken care to document and send follow-up emails to the employee, you will be able to produce the proof that you followed a progressive course of dealing with the issue. If you need to terminate the employee, you want to make sure it's not a rash decision, and you need to make sure you have protected the library from lawsuits for unlawful termination. As previously stated several times, you need to discuss the situation with an HR person in your community or an attorney, perhaps both, before termination is taken. If you work in a library that has a union, there will be a detailed process written into the contract that outlines the required steps for discipline or termination. Make sure you understand those steps and guidelines. Types of documentation can include employee performance evaluations, initial complaints made by patrons or other staff, witness reports, written materials relevant to the situation, including emails, as well as library policies, meetings with the employee. Keep a record of the date, time, place, and details of conversation. The employee's personnel file, which should have records of all of the aforementioned documentation. Any discipline or termination reports, and individual notes of supervisors or other managers. Here are some questions to ask as guidelines for making a discipline decision. Was the employee given prior warning of the consequence of their conduct? Was the library's rule reasonably related to the efficient and safe operations of the library? Is the discipline consistent with past actions under similar circumstances? In other words, if a previous employee committed a similar infraction, is your course of discipline similar to what happened with that other employee? This is when communicating with your city and other city department heads may be useful. Was the discipline reasonably related to the seriousness of the offense and the employee's past work record? This is looking at the big picture of the employee and making the discipline fit the offense. Consistency is extremely important, so you want to have not only consistency in addressing the situation, if no improvements are made by the employee, but also consistency in addressing similar behaviors that may be noted in other employees. You cannot expect to come down hard on a new employee who is habitually late to work when some of your long-term employees are already routinely showing up late for work and nothing is being done to them. Here are some suggestions on how to conduct a successful meeting to talk about any discipline. These recommendations come from the Society for Human Resource Management. Keep any meetings or discussions with the employee private. Sometimes that's difficult to do in a very small library, but try to find a quiet, non-public space. You may need to schedule the discussion at a time just before the library opens to the public. Realize that embarrassing the employee in front of others isn't going to move the process toward a mutual solution. Note that if the library board is disciplining the director, such a meeting is subject to Iowa's open meetings law. Consult with the state library's law library if you have questions about this. Consider having a witness, especially in disciplinary meetings that occur later in the process. If the discussion could potentially become heated, then having a neutral party is advised. This could be another library director or another manager or supervisor from your system. Having someone from HR or the city would be preferable. In a disciplinary meeting, which differs from a first verbal warning, don't give mixed messages. In other words, don't compliment the employee on something they do before calling them out on something else. Deal with the issue at hand. Tell the employee exactly what the problem is, the steps to fix or change the behavior, and the consequences if that doesn't happen. Remain calm. This is sometimes more easily said than done, but you must do your best. If you're upset, the chances of the discussion escalating is very high. If tensions begin to rise too much, end the meeting and schedule it again for another time. Be respectful. Let the employee know that you do want them to improve and that you are willing to help make that happen. Be sensitive to their feelings and use constructive criticism, although sometimes any criticism is hard for others to take. Explain the impact of the violation, how the employee's actions affected patrons or other library staff, or perhaps the library overall. Doing this shows you are focusing on the library and not the employee's personal attributes. Work to find solutions. This helps the employee to view the situation as an opportunity to succeed instead of feeling like they've been set up to fail. It also shows your willingness to help the employee succeed. Clearly state the consequences. Be clear about what happens if the agreed upon changes don't occur. Make sure the employee understands those consequences. Provide opportunity for employee comment. Give them a chance to provide their side. They might not necessarily agree with the course of action, but let them be heard. Have them acknowledge the discussion in writing, even if they don't agree, as this indicates they were part of the discussion and they can't say later that they were never told. Provide a document, one that lists the offense, the process, and the result. Include a place for signatures and date of both you and the employee. One copy can be given to the employee, and the original copy is placed in the employee's personnel file. You must notify the employee in writing that the information placed in the employee's personnel file as a result of the disciplinary action may become a public record as outlined in Iowa Code. After the meeting, make sure you continue to follow up with the employee and look for improvements in their behavior or performance. Address any uncorrected situations within the time frame given for improvements. In our class about performance evaluations, part of this HR and volunteer management course, we talked briefly about performance improvement plans. This slide includes a URL to information and a template for performance improvement plans. Be sure to access the class about performance evaluations, as the information in that class definitely ties in with this current class. Going through the previous processes will hopefully mean you rarely end up at this final step of termination. Realize that employees who are fired can easily file for unfair termination with the Equal Employment Opportunity Commission, or EEOC, on various grounds, including race, sex, gender, religion, age, or political beliefs. There are situations where immediate termination is needed, but make sure you discuss with an attorney prior to doing so. We cannot overstate the importance of consulting with an HR expert or attorney, preferably both. When you've done everything you can to improve the productivity or work problems with the employee to no avail, termination is the next and final step. This is definitely a stressful situation for all involved, not just the person getting fired. Remain calm and don't give the impression that your mind can be changed at this point. Set up a face-to-face meeting with the employee. Approach the employee with kindness and respect, but be straightforward. The decision has been made. Have a witness sit in on the meeting so you have someone who hears the conversation and can pick up the conversation if needed. Keep it short. You will get asked why, even if you've gone through a long discipline process. Employees never think termination will actually happen. Have an answer prepared that is honest and summarizes the situation without detail or blame. Provide the employee with a written statement of the termination, indicating if there are benefits to be paid out and how that will happen, any details about a final paycheck, etc. The conversation might not touch on those topics, so you want to make sure they are covered in writing. Again, consult with HR or the city before putting anything in writing. Have the employee leave immediately because you don't want them to take library property or discuss this with other employees or patrons or have opportunity to undermine anything such as the library's email or social media accounts. If necessary, you can set up a time to have them come in and get their personal items after you have had a chance to pack them. Disgruntled employees have been known to cause damage to equipment, property, or computer files if allowed to stay in the library. Request that the employee hand you the library key if the employee had one. Also, make sure the employee no longer has access to library email, website, social media, and other similar accounts, lest they opt to make changes or send damaging messages. Be sure to have all passwords to any such accounts changed immediately, in fact, just prior to terminating the employee. After the employee's termination, you need to provide a message to the remaining staff that the person is no longer employed, but you have to maintain the employee's confidentiality, so you cannot discuss reasons or specifics. If you have a small staff, that can be harder because mostly the other staff are probably aware of the problems already. However, be very careful about what you say. It is very possible that the fired employee will post something on social media that makes them look good and you look bad. Don't be tempted to respond. Your actions will determine how other staff view you. If you have followed the recommended procedures and consulted with your city, your HR expert, and your city or local attorney, you should be in much better shape if you ever have to reach this step in managing employees. Here are some warnings for employers about things that can be troublesome should employment litigation ever occur. Failure to document the various employee issues. As mentioned throughout this class, you need to document everything with details and dates. Failure to properly train employees. You can't fault an employee for violating patron privacy if you have never properly trained the employee on that topic and the procedures for maintaining it at your library. Failure to keep documentation. This is similar to failure to document, but this is where you created the documentation but then disposed of it. Keep such documentation for several years. Our state law library provides this information. It may be best to gather the applicable electronic and hard copy documents at the time of termination and preserve them instead of waiting until you receive notice of a claim. It's better to think ahead about potential problems than to look back at avoidable mistakes. Consult with your city attorney to learn exactly how long you should retain various employee files. Performance grade inflation occurs when you give better performance evaluations to an employee than what they earned. See our class about performance evaluations to learn how to best create evaluations. Performance evaluations will become evidence should employee litigation be filed. Failure to consult HR professionals or your city attorney. If the terminated employee later files a lawsuit for unfair termination, the court will want to know if you did due diligence by consulting with professionals prior to the disciplining and firing process. Inappropriate emails, such as communication between managers that may use derogatory verbiage about an employee. Always assume that every email you send and every comment you make may be read by other people, including a judge and jury, should litigation occur. Also realize that your emails are subject to public scrutiny through FOIA requests. Also realize that even after the employee is gone, you must be careful about what you say. As mentioned in a previous slide, you need to be consistent in how you deal not only with the current employee, but also with all employees. You need to address all employees' behavior consistently. Additionally, you need to be consistent in your follow-up with any employee disciplinary measures. If you said you would have another evaluation with the employee in 3 months, then you need to conduct that evaluation in 3 months. As repeatedly stated, you should consult with your city's HR manager about any employee disciplinary actions. If your city does not have anyone in an HR position, contact the Iowa League of Cities, which has someone on staff that specializes in HR issues and can help you with your questions. And you should always seek professional legal advice from your city attorney. Our state law library says, The two most important pieces of policy advice in regard to employment termination are to make sure all job performance issues have been properly documented and to make sure you call your city attorney early in the process. It is far better to pay up front for a consultation with your attorney than to spend large sums of money on countless hours of attorney time required to deal with possible employee litigation down the road. This concludes our class about disciplining and firing.